Hi guys. So today I want to discuss what it means for a trust to be completely constituted, and the approach I will be adopting today will be to use the questioning method, meaning I'm going to select a question and I would attempt to provide an answer to it, and also use that opportunity to render an exposition on the nitty-gritty of the principle of trust, that for a trust to be valid, it must be completely constituted. My name is Yusuf Oluwafemi Salako, and I'm popularly known as Ori David. I am the founder and head of research of the Ori David Consult, and I welcome you to today's edition on the law of trust. So as you can see on the screen, I have a question here. It's a question from the University of Lagos Faculty of Law, 2016, question number 3A. And the question says that in order for a settlor to create a valid trust inter vivos of property, it is necessary both to constitute the trust perfectly and to meet certain statutory requirements. Discuss. Now, when we see a question as a law student, the very first thing for us to do is to characterize the question. What does it mean to characterize a question? It means to take time and ponder or pore over the question and ask yourself the question: what exactly is this question asking me? What exactly is the examiner looking for? What area, what principle of law is this question, does this question touch on? And it is in a bid to help you with that we have provided answer plans and some lead questions. So the answer plan is for you to, it says in order for a settlor to create a valid trust inter vivos of property. Now, what does it mean when we say for a settlor to create a valid trust inter vivos of property? Of course, it means for you to create a trust while alive. Inter vivos means while alive. And you know that when we have a trust can be set up either by a settlor or a testator. A settlor meaning the person or the individual set up the trust while he was alive. Testator in the sense that the trust was set up through a will, that is a testamentary document. Now it says for you to be able to do so, for it to be valid, it is necessary both to constitute the trust perfectly and also to meet certain statutory requirements. So this question is basically asking us to discuss what it means to constitute a trust perfectly, and what does it mean to also meet certain statutory requirements, and what connection do these two conditions or requirements or criteria, so to say, have with the issue of the validity of a trust intended to be created or set up inter vivos. And these are the answer plans. What is the distinction between a trust by declaring a settlor as trustee and transferring property and likes? And so now, how do you answer this? Of course, we have a model answer here. Of course, when you look at this, we try as much as possible to make our answer to be somewhat formal, our answer to try as much as possible to achieve some level of standard. But as students, in the exam hall, you may not have the opportunity of time for you to be able to do this. So all you have to do is to make sure that you focus on what you need to focus on. That is just for you to explain, to espouse on the nitty-gritty of the question. At any rate, now the very first thing you need to pay attention to is that, you see, trust is a unique creation of common law and is one of its most versatile concepts. And the trust of trust essentially means that an individual is kept in charge of a property to be held for the use and benefits of another individual. So meaning when you are said to hold something on trust, it automatically translates into that you are not the owner of the property. Instead, somebody has put you in charge of the property. And the person putting you in charge of the property is not even saying that, okay, you are to use this property to your own benefit. No, the person is saying that you are supposed to hold, to manage this particular property for the benefit of another individual. So the person who is the original owner of the property can either be the settlor or the testator. I've explained these two concepts. And the one put in charge of the property is known as the trustee, while the one on whose behalf the property is held is the beneficiary. So now, when you have understood what you have understood this, of course, you have to appreciate that at times when a trust is set up by an individual, the individual himself setting up the trust may end up becoming the trustee, such that you used to be the owner of a property, but you can then decide and say, okay, from today onward, I no longer hold this property as my property. Instead, from today onward, I hold this property on behalf of Oluwafemi. So it means that you have changed your status from the absolute owner, the original owner, to a trustee. In the same connection, you have to also understand that the owner of a property can as well become a beneficiary. Yes, can as well become a beneficiary in the sense that you used to be the owner, absolute owner of the property, but you decide to put it up on trust by transferring the property to another individual for the person to hold on trust, that is on your behalf, to your advantage, to your benefit. You automatically become the beneficiary. So, these are concepts you should keep yourself abreast of. While you have also understood that, then you understand also that a trust can be created inter vivos, or can be created when that is through a will. Now, when you have then understood all of this, it is also possible for you to appreciate that when a trust is to be created inter vivos, there are certain ways in which the trust may be created, and this was one aspect of the law of trust that the court in Mirror versus Lord actually expounded on. Now, to create a trust while you're alive, there are ways. The first is that you can declare yourself to be the trustee. That is self-declaration of trust. I cited the example earlier. I'm the owner of this laptop, and I said from today onward I want to put Ori David in charge, assuming Ori David is another individual in charge of this laptop. You should hold it on trust for, say, 3C. So automatically what it means is that I've transferred it to another individual. Of course, this does not reflect this particular method of creating a trust, because the method we are interrogating is where you declare yourself to be the trustee. So if I'm the owner of this property and I say from today onward I no longer hold this laptop to my own benefit, instead I hold it on behalf of TLC, that means that I've declared myself as the trustee. So that is one way, and you see that this was captured in a Mirror versus Lord. Now, of course, there are several reasons why you may want to do so, but the uses of trust will form the crux of another lecture, not this one. Now, that is the first way. Now, according to Mirror and Lord, another way of actually creating a trust is that you may then transfer the property to another individual, in the sense that you are not declaring yourself as a trustee in this instance. What you're doing is you are transferring the property to another person and say, okay, from today I want you to hold this property that used to be mine. I want you to now hold it on behalf of so person. So that means you are transferring the property to another individual. Now, whether it is self-declaration of trust, whether it is that you're transferring it to another individual, one thing the law says is when you want to create a trust, where either by self-declaration or by transferring the property to another person, that is to act as a trustee, the law says that the trust must be completely constituted. So this expression, completely constituting a trust, forms or is the cornerstone of our analysis for today. The question is, what does it mean to completely constitute a trust? Another question we may also be attempting to supply an answer to is, how do you completely constitute a trust? Now, to answer the first question, what does it mean to completely constitute a trust? What it simply means is that the trust must be perfect, in that the beneficiary must be able to enforce it. But that is also a more complex way of explaining what this expression means. Because the simplest meaning of this expression is actually that the settlor or the testator, pardon me, in this instance we are looking at where the trust was created inter vivos. So there is no need for us to start saying settlor or testator. We are limited to the settlor. Now, what it simply means is that the settlor must do everything within his capacity to transfer the legal title, the title that he used to have in the property. He must do everything to transfer it to the other individual. Now, when we're saying transferring it to the other individual, remember that according to Mirror versus Lord, you can take two approaches, or two ways of creating a trust, either through self-declaration or by transferring properties to another individual. So in self-declaration, does it not mean that the person that owned the property used to be the owner, and he's saying that, okay, from today he wants to hold it on trust for another individual? So what does it mean when we say he must completely constitute the trust in that instance? Because completely constituting the trust, like I've stated earlier, means you must do everything within your capacity to transfer the property to the trustee. Then it means essentially that in self-declaration, the same person that used to be the owner will then declare himself as a trustee, and for him to completely constitute the trust, it means that he must do everything within his capacity to transfer the property, the title in the property that he used to own, to himself, but now as a trustee. Of course, I would explain that later on. And this also applies to the second way of creating a trust, that is by way of transferring to another individual. So if, for instance, I'm the owner of this laptop, and when I said, okay, from today I want to transfer it to Ugba, and that's Ugba. I'm not transferring it to Ugba as a gift. I'm not giving it to Ugba. Instead, I want Ugba to hold it on trust for TLC. Now, it means I'm the settlor, Ugba is supposed to be the trustee, and TLC is supposed to be the beneficiary. Now, by saying it must be completely constituted, the law is saying that I must do everything within my capacity to make sure that every ownership right that I have as far as the property is concerned, I transfer it to Ugba, meaning the legal title, the title I used to have, Ugba must now be the one to have it. If I do not do so, that's attempted trust. Yes, I say attempted trust because it's not going to be valid. And the reason for this is that the law will say it has not been completely constituted. So what it means essentially is that the rule of common law says that for a trust to be valid, the trustee must be invested with the legal title to the trust property. Yes. Now, I've also explained that means you transfer the property to the trustee. Now, when you say the trustee must be invested with legal title to the property, then it means that we have to appreciate that there must be a distinction, or there must be certain peculiarities that would affect the nature of creation of trust. And what I mean is, if we say that a trust can be created by way of self-declaration, and we are still saying that even that trust must be completely constituted, essentially we are saying that you should transfer the legal title to the trustee. But in this instance, we realize that the trustee, the person that is supposed to be the trustee, is the same person that is the owner, because the person is just declaring himself as a trustee. So what does it mean in that instance for the person to completely constitute the trust? Because I've explained that for him to completely constitute the trust, it means that he must transfer the title in the property to the trustee. But look at this. I want to create a trust by declaring myself as the trustee. And the law is saying I must completely constitute it meaning the law is saying that I must transfer the legal title to myself. But if I were the owner, does it not translate into the reality that the title was already vested in me? So, and I'm supposed to be the trustee. So the question is, who am I transferring it to? Why am I transferring it to who? How? So we need to appreciate that distinction. So with respect to this, that is when there is self declaration. So the question we want to ask is, how can the settlor who already owns the property become vested with the legal title? Of course, one thing you have to understand that when the method to be adopted is by way of self-declaration, it poses little or no challenge to basically fulfill this condition of law, in the sense that the person who is to be the trustee already owns the legal title, so there is no need for him to transfer the property, and there is no need for any formality as such. The only legal requirement in this instance is that he must make an effective declaration of himself as a trustee. So all you just have to do is just declare yourself as a trustee. Just say, from today onward, I am no longer the owner of this, and instead I will be holding it on trust and all. And if you look at the case of Paul versus Constance, it stands for the proposition of law that such a declaration is a clear evidence of a present and irrevocable declaration of trust. Pardon me. Now, that is that. But I need to point out that where the subject matter is land or an interest in land, then matters are not that straightforward as I earlier painted. That is, even where it is self-declaration and it's supposed to be easy, all you just have to do is to declare yourself as trustee and you have completely constituted it. You have to understand that the nature of the property is of crucial importance, even with respect to self-declaration of trust. Because where the subject matter is land, or it involves an interest in land, then the settlor has to do more than just to make an effective self-declaration. This means he has to show evidence of such declaration in writing. It's not just about the fact that, okay, I declared myself, because there could be oral declaration. But if it involves land, you don't just adopt any method to declare yourself. The law says you must show it in writing. And this is in line with Section 7 of the Statute of Frauds and Section 78, Sub 1, Paragraph B of the Property and Conveyancy Law. It is important to clarify that for this self-declaration to validly constitute a trust, there must not necessarily be any evidence showing that there was a failed attempt by the trustee to create a trust by transferring the property to another individual. So what we mean is, if you want to adopt self-declaration of trust, then you should adopt it. Not that it should be some sort of last resort. It shouldn't be that you already attempted to transfer the property, that is to transfer it, but then because that failed for one reason or the other, then you wanted to now revert to self-declaration. No, you cannot commingle both of them. And that is why the law says that what self-declaration of trust must not be as a result of failure of an initial attempt to create a trust to the other route. And you can see that the law tried as much as possible to provide justification for this in the court, rather, in Mirror versus Lord, where the court said the intention to create trust by way of self-declaration is fundamentally different from an intention to do so by way of transfer, and that both are mutually exclusive of the other. So try as much as possible to decide which one you want to adopt, and don't commingle both of them. And still also on the discourse of creation of trust by way of self-declaration, but to the second method instead, that is where you're transferring the property to another individual. Now, this is an aspect that produces much bewilderment, so to say, because it may become confusing and somewhat complex. And the reason for this is not far-fetched. Of course, now the original owner, the person that used to have the legal title, is now to transfer it to another individual. And I said that so completely constitute trust means you must do everything within your capacity to make sure that you transfer the legal title you have in the property to the trustee. The trustee must now be the one to have the legal title, not you. You cannot create a trust and then you, the settlor, you are still vested with the legal title. The trustee will become incapacitated and will not be able to discharge his duties imposed on him by law. And it will also make the beneficiary to also as well become incapacitated to enforce the trust against the trustee. And that's what the law says, you must completely constitute the trust. So when you are when you want to create a trust by transferring the property to another individual, what you are actually transferring is the legal title. So until the moment you have successfully transferred the legal title, the law says a trust has not been validly created, and that is what is meant when it is said that the trust is not completely constituting. Now, on this transfer of property, you have to understand that when the legal title to a property is said to have been validly transferred to another individual, there is an assumption that such a transfer has been done in accordance with the law governing the transfer of the legal title in the property. Now, what we are saying is, since you are transferring property from one person, you the original owner, to another individual, and the law is saying that, okay, if you're going to transfer it, you are transferring the legal title, then you have to understand that the nature of the property is very important, because there are different laws. There is an array of laws that governs different property. So the nature of the property is very important in this instance, because it is the nature of the property that will determine what approach to take, in the sense that what does the law say on the transfer of the legal title on this property. Because you cannot compare when you want to transfer, say, an intangible property, say a choosing action, say copyright, patent, trademark. You cannot compare it when you want to transfer something that is tangible. Say you want to transfer a laptop, your mobile phone, or perhaps you want to transfer land, or you want to transfer shares, and all of these properties, so to say, they have there is a different regime of laws that govern them. So, which means we have to also pay attention to what the law says. Meaning, if you do not follow what the law says about on transferring, then it will be taken that you have not transferred the legal title, and it will then translate into that you have not validly created a trust because it has not been completely constituted. So, meaning that we have to look at the different types of property that may become the subject matter of a trust and what the law says on them. So you have to interrogate them. So for instance, if the property to be transferred is a land, then a deed of assignment must be executed, and governor's consent must also be obtained. Because this is the reason for this is that the Land Use Act provides for this. That is just the reason. So the Land Use Act has said, if you want to transfer title, this is the way to transfer title. And if you check sections 22, 23, and 24 of the Land Use Act, a holistic reading of these provisions will produce this legal proposition that there must be governor's consent obtained. Of course, there are certain exceptions to that, but we really do not need to delve into that. Now, when the property is not reality, that is not land, but personality, that is can be tangible or intangible, you have to avert your mind to what the law says on the proper investiture of a legal title. That is, what is the legal position, legal provision, what's the position of the law on transferring of such a property. So if, say, it is a choosing action that is to be assigned, for example, say shares, the law, when you look at sections 175 and 176 of the Companies and Allied Matters Act of 2020, remember that 2020 has come to replace the former one we used to have, that is 1990. So this is these are the sections that are relevant here, and you see that these sections practically provide that where you want to transfer your shares, that is ownership in shares, to another individual, it only becomes effective when such has been entered in, the register of shares. So if you want to transfer your shares to me, then it must have been registered in the register of shares, that the shares that have been transferred to me. If this has not been done, then automatically means that the shares have still not been transferred to me. So until you registered, the shares will not be deemed to have been registered. Additionally, where the property is a debenture, that is a secured loan, a deed must also be executed to that effect. Remember that a patent is also a choosing action and can also be transferred. Then a patent can be assigned and licensed, but the law says such assignments are ineffective if they are not in writing. Additionally, where the property is a tangible property, say a car that can be transferred by delivery, then there must be either a delivery or some sort of deed of a gift. So meaning you look at the law, you look at the property, look at what the law says on how you should transfer that. If you want to transfer ownership, how? Say you want to even sell it, how? What does the law say you should do? Then you must do the same thing with respect to the trustee. That is what we are saying. Now, do appreciate that the consequence of any failure to validly transfer the legal title to the donee, that is the intended trustee, is that such an attempted trust will fail for being an imperfect gift, and it means there will be no trust. So in the absence of a trust, then the beneficiary will have no claim for enforcement, of course, save certain exceptions. And you have to see that this was reinforced in the case of Richards versus Delbridge. So if no trust has been created because the settlor has failed to transfer the title he has failed to transfer it to the donee, that is the intended trustee, then the beneficiary has no claim against him. Of course, there are certain exceptions to this. So let us look at certain cases. Let's look at the case laws on this. We look at start with Richards versus Delbridge, where there was a lease, and in that lease a note was signed. The note was not under seal, and the trust of the note was basically to say that okay, they had transferred the stock in trade to Edward Benneto Richards, but then the court held that the gift failed as the attempted assignment passed no legal interest and was not a declaration of trust. In the same connection, you look at Antrobus and Smith, where there was some sort of endorsement on the receipts for one of the subscriptions to a navigation company, purporting it to be an assignment to the assigner's daughter of all his right title and interest in the call. It was in the vote to support this as a declaration of trust. The court also refused to enforce the assignment on the ground that it could pass no title. Furthermore, in Lord and Mirror, Lord and Mirror was a case where Thomas Medley was a shareholder in a bank of Louisiana. He wanted to transfer his shares to his niece, but then the bank demanded that he did so in line with its regulations as enshrined in its constitution. And Thomas signed a deed in Louisiana with Samuel Lord for the latter to hold 50 shares on trust for Eliano. He also executed a power of attorney in favor of Lord to receive dividends on the shares and to comply with the company's constitutional formalities. However, Lord did not do any of this. Then Thomas died and the shares were still in his name. However, Eliano Mirror, his niece, claimed that the shares belonged to her. Of course, the shares were to be held on trust for her. These arguments found favor at the Court of First Instance. However, the Privy Council held that Medley did not make a transfer of the shares to confer the legal proprietorship on Lord. That is, Medley did not do everything that he needed to do to make sure that the trust had been transferred. But then, perhaps it's also important for us to look at the case of Jones and Locke. Jones and Locke was a case where a father who has just returned from a business trip, he had no gift for his infant son, but then he put a check of £900 in the baby's hands with certain statements such as, "Look here, I give this to baby. It is for himself and I'm going to put it away for him, and we give him a great deal more along with it." Then Jones locked the check, which was not endorsed, that is, it was not signed at the back, in the safe before he died 6 days after. And it should be appreciated that Jones had a son with first wife and an infant son with his second wife. So the second wife's child is the beneficiary of the check, that is the subject matter of the controversy in the case. It's just important to put it out there that Jones did not amend his will. So it means that the rest of his estate was to go to the children of his first wife. Then the infant's mother said, okay, at least the £900 out of the estate had been transferred to Jones' son when Jones was alive. The court held that this was not possible because there was no trust created in favor of the infant's son. The court noted that what had happened was a loose statement made by Jones, and that evidence showed that the intention was to make a gift of the check to the infant, not to declare a trust. Also, it is important for we really do not need this. Now, we've stated that when the trustee is not vested with legal title to the property, the trust is incompletely constituted, and then it automatically means the beneficiary will not be able to enforce it. Are there exceptions to this rule? Of course there are. There are 3 instances in which an incompletely constituted trust or gift may become perfected. First, a trust may be given a stamp of validity despite the fact that the trustee has not formally received legal title, if failure to do so is beyond the control of the donor. So what it means, the crux of this whole completely constituting a trust is all about the fact that the donor must do everything within his capacity to transfer the title. But the question is, what if he has done everything and despite doing everything humanly possible, was not able to transfer the title, but his failure to transfer the title was beyond his control, that no one in his position could have done more than he did? Should the law still say that, okay, the trust has not been validly created or completely constituted? Of course no. The position of the law is that where the failure of compliance is as a result of external factors beyond the control of the trustee, the Court of Equity may hold that the trust is completely constituted. And our authority for this is the case of Rose. In Rose, a trust of shares in a private company had not been confirmed at the relevant time because it had not been entered in the company's share register. Of course, we looked at 175 and 176 of Common. The court held that the trust was still completely constituted, and the reason for this was the court said the finality of the transfer of legal title was to be determined by the directors, and that the directors had the discretion to refuse such registration. So meaning that the complete transfer of legal title was beyond the settler's control. The directors had discretion, even if he does everything possible. You directors, they still have to be the one to make that decision. That was beyond it. So the second exception to the rule that where a trust has not been completely constituted, it is not valid and the beneficiary will not be able to enforce it, is where the trustee acquires the legal title to the trust property in a way different from that intended by the original owner. So say for instance, the settlor failed to effectively transfer the property to the trustee when he was alive, but then he went ahead to still appoint the donee, that is the intended trustee, as the executor of his will. The executor, who is now the trustee, will automatically obtain legal title as an executor, and the fate trust becomes completely constituted. And this has become popularly known as the rule in strong and bed. The rule in strong and bed will also form the trust of another analysis in another video. Summarily, the rule in strong and bed is simply that the vesting of property in the personal representatives of the testator completes the imperfect gifts which he made in his lifetime. And you see that this principle has also been reinforced in the case of re-rally. And then the third exception is that other methods such as donatio mortis causa, that is when you give a gift when you're very close to, or where death is imminent, and proprietary estopels may also be explored to transfer title from one person to the other, without necessarily following the normal general formality rules. And these are the exceptions. These are the 3 exceptions to the rule where the trust has not been completely constituted. It will not create a valid trust, and the beneficiary will not be able to enforce it. And these are the exceptions to that. Now, one further thing to pay attention to is that all this exposition, this analysis, and all, they are still centered on, the common law rules on the need for the legal title to be transferred to the building. However, you have to appreciate that aside this common law rule, there are statutory requirements that also need to be fulfilled. That is, these statute laws ordinarily, they are not of original or intrinsic nature or character to the nature of trust. Instead, they are external requirements, and they are made because the legislature wants to prevent fraud and also ensure certainty. So, with respect to this aspect of the requirements, the nature of the property of intended trust is also of crucial importance. Where it is personality, that is no land or interest in land, you don't really have any stringent requirement or elaborate requirement like that. It's enough that you have declared a trust or you transfer same, and it can be done either orally or in writing. But if the subject matter is land, the law says in section 53 sub 1 of the Law of Properties Act of 1925 England that it must be evidenced in writing. But appreciate that being evidenced in writing is not the same thing as that the trust must be in writing. It's just that there must be written evidence of the fact that the trust exists. Now, if you do not follow this, then the trust will become unenforceable. In Nigeria, you can also see the Statute of Fraud, Section 7, the Property and Conveyancing Law. The Property and Conveyancing Law applies in other states of Nigeria aside the states consisting of the former western state of Nigeria, Oyo, Ogun, Lagos, Edo, Delta, or whatever. Then, the provisions of Section 78 sub 1 paragraph B of the Property and Conveyancing Law are in pari materia with Section 53 sub 1 of the Law of Properties Act of 1925 England. So we have already analyzed them. Operations of trust generally, by and large, that involve land must be manifested and proved by some writing. Okay, I think once you have been able to talk about all of this, then you should appreciate that you have done some sort of justice to this. So with this analysis, interrogating this question, at least we have been able to understand that a trust can be created while alive or through a will that is set law or statutory in the Bibles and all. And we have also been able to point out that you can declare yourself as a trustee, or you may transfer the property to another individual. And we have also been able to also show that for a trust to be valid, it must be completely constituted. And what it means for the trust to be completely constituted is that you must do everything within your capacity to transfer the legal title to the intended trustee. And we have also been able to show that there are different ways to do so, and that the nature of the property will determine what you need to do, because there are certain laws that govern the transfer of title in a property, and so you have to follow the law. And we've also been able to look at certain exceptions to this rule that says if it is not completely constituted, it is not valid, and automatically means that the beneficiary cannot enforce it. And that is that on trust. If you have any question, you can drop it in the comment section below. I'll make sure to provide useful information on this. And if you desirous of being a part of our online classes or even physical classes, you can also reach us through the different contacts, which I will also be dropping in the call, down below. So reach out to us, and also perhaps if you have any of your written your writing commitment, pardon me, perhaps you want to read it, or perhaps need guidance, consultation and all, you can also reach out to us. Once again, my name has not changed, for I remain Oluwafemi Salako, popularly known as Ori David. Till I see you next time, do stay cheeky. Thank you.